That was National Assembly Bill number 52 of 2023. This understanding was thereafter communicated to the Cabinet Office on 28 February 2024. We consequently went ahead to make our contribution to the National Assembly Departmental Committee on Parliamentary Broadcasting and Library in the same month, and on that same month. And I believe the same Committee of Parliament consulted the State Law Office to work on that bill. And we are happy that they have brought back the bill to the State Law Office for further inputs. I therefore do reiterate my gratitude to the Office of the Attorney General for its renewed drive towards development of the legislation on public participation. The Office of Parliamentary Affairs shall be reverting with preliminary comments as requested in the invite. Nevertheless, ladies and gentlemen, allow me to highlight two comments on this matter. One, there is a current appreciation of what needs to be done in order to realize meaningful public participation. Under this current appreciation, the government duplicates public participation for matters to be considered by the two arms of government. We have public participation conducted by the National Executive under Articles 10(2), 69(1)(d), 201(a), and 232(1)(d) of the Constitution. The same matter are again subjected to Article 118, public participation when they transit to Parliament. As a result, colleagues, there is inefficient utilization of time as well as limited resources available to us as a country. It has also meant that the timelines for delivery of legislative agenda are dictated in a big way by how quickly an MDA can marshal financial resources to push their initiatives past public participation, and more particularly to facilitate the region or county level public participation forums. This point is key because of the resource aspect of it. And I want to request as we progress, we consider that. Our policy proposal invites us to eliminate this duplicity embedded in our current public participation practice. This invite is supported by the fact that the government of Kenya is one with various arms charged with distinct functions. Where processes require both arms of government, the executive should be extremely empowered to undertake targeted public participation, otherwise known as stakeholder engagement, while Parliament, as the law-making and representation arm of government, conducts its Article 118, public participation. It is to be noted that Parliament's public participation is further strengthened by the standing orders and various provisions of the Parliamentary Service Act. Open public participation should, however, apply for matters that either terminate in the executive or which Parliament doesn't subject to public participation under Article 118. Such matters include statutory instruments, public policy, and such aspects of programs and projects that terminate at the executive. I'm happy to note the legislative proposal addresses the duplication of public participation efforts as between the National Assembly and the Senate under Clause 15 of the proposal that we are looking at now. We can similarly explore the possibility of taking it even further by addressing the duplicities as between the two arms of government. I invite the Office of the AG to consider the constitutionality of this proposal and the possibility of introducing a clause in the bill that recognizes open public participation and targeted public participation as categories of public participation. Ladies and gentlemen, that was one aspect. The second aspect, as I finish, relates to the development of specific public participation guidelines. While good in idea, this provision prevents implementation challenges which should be ironed out. I proceed to demonstrate. One, as I noted earlier in the remarks that I've given, some sector laws have public participation set out as part of the general values and principles guiding the application of the law. Others have entire chapters titled Public Participation and Access to Information, while others provide for regulations on public participation. Two, from a coordination perspective, the requirement for specific guidelines and the adoption of the general guidelines set out in the bill may likely cause a conflict of laws between the standalone public participation law and sector laws that already provide for public participation modalities. Should a public entity apply the modalities under its sector law, or should it apply the guidelines under the public participation law? This presents a compliance puzzle. 3, to forestall this potential conflict, the Office of the AG may consider amending the bill to either exempt the application of Part 4 on specific guidelines for public participation to public entities whose sector laws have expressed provisions on public participation, or include a conflict of laws provision that prevails the public participation law in case of conflict with another law. Ladies and gentlemen, this is a very good initiative, and once we get this, or we deliver this, we shall be right as a country in terms of how we process our policy, legal, and institutional frameworks. I most sincerely thank the Office of the AG for this opportunity and look forward to the much needed legislative settlement on this issue of public participation. I thank you.